Hey there, I'm attorney Bobby Buchanan, an Illinois divorce and matrimonial lawyer, and today we're going to talk about alimony, also known as maintenance, in an Illinois divorce, specifically how it typically works and whether you can waive it. First things first, to determine if a party is entitled to maintenance, a judge considers 14 various factors outlined in Section 504 of the Illinois Marriage and Dissolution of Marriage Act. This includes the income and property of each party, the needs of each party, the realistic earning capacity of each party, and other factors. If a judge determines a party is entitled to maintenance, the maintenance award is broken down into two components: duration and amount. Duration is determined by the length of the marriage as set forth in the statute. For example, a 10-year marriage would typically result in a 4-year maintenance award. The statute provides varying lengths of maintenance depending on the length of the marriage. The amount of maintenance is calculated by taking 33.33% of the payer's net annual income minus 25% of the payee's net annual income. However, the amount calculated as maintenance when added to the net income of the payee shall not result in the payee receiving an amount that is in excess of 40% of the combined net income of the parties. Now, can you waive alimony? Yes, you can. But it's important to understand how it's calculated so you can make an informed decision. Waiving alimony means that you're giving up your right to it, so it's not a decision to take lightly. However, in some cases, couples agree that neither party will seek alimony from the other. If you have any questions about alimony or divorce in general, please reach out to us. We're here to help.